This is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're in session number 7. Session number 7, if you can believe that. This is our final session in our new program entitled the QME Forensic Super Sleuth. And if you've been following this session, I want to thank you for your perseverance and your dedication to excellence and your commitment to being the very best qualified medical evaluator that you can possibly be. And in today's session, I have a fascinating discussion for you, one of which is going to put the finishing touches on all of the things that we've discussed in this program about what they don't tell us. What they don't tell us. So the entire philosophy of this whole program, the QME Forensic Super Sleuth, is how you as the qualified medical evaluator need to be a inquisitive and persistent forensic investigator to get to the bottom of the issues that the parties, the players, the people don't tell us. So the parties include the claims administrators, include any attorneys involved with the case. The parties include the examinee who sits in front of you in the face-to-face evaluation. And in today's discussion, we're going to talk about the parties that confront you in the hot, steamy, boiler room, sweaty boiler room of the deposition. And in session number 1 of this program, let's just talk about where we've come so far in this program. In session number 1 of this program, we talked about QME Forms 105 and 106 and how the parties don't tell us the need or the issues that drive the need for your QME evaluation. And we talked about how represented versus unrepresented injured workers come to the QME evaluation through different pathways. And those pathways go through QME Forms 105 and 106. And on those forms, the parties indicate the reasons or the disputes that drive the need for your evaluation. But unfortunately, we as qualified medical evaluators, we're not provided access to those forms. And so many times when the examinee comes to us, we're unaware as to the issues that we're being called upon to resolve. So I provided you an algorithm to help you discern at the very outset of your evaluation what are the issues driving the need for the evaluation, and then therefore what is the sequence of steps that you're going to pursue in engineering your evaluation. In our second session, we got into the law books and we talked about labor codes 4060, 4061, and 4062. And these are the 3 labor codes that govern the QME panel process, the process by which your name shows up on a 3-doctor panel, and the process by which your name is selected from the panel by either the claims administrator, by the injured worker themselves in the case of an unrepresented injured worker, or the way that you are left as the last man standing in the case of represented injured workers. And each of these labor codes governs a different issue that drives the need for your evaluation, many of which we're now getting these days under Labor Code 4060, which is the compensability exam to determine the presence or the absence of an industrial injury. And these are the types of cases that you're going to be seeing a tremendous volume of throughout the remainder of your career. So we talked about how to discover those cases that are governed under Labor Code 4060, how to discover those cases that are governed under 4061, and how to discover those cases that are governed under 4062, and then how to handle each of those particular cases. In our third session, we had a fascinating discussion about the largest growing segment, the largest growing species of claims that we're seeing as qualified medical evaluators. And this has to do with the post-employment claims, both in the form of post-employment specific injury claims and post-employment cumulative trauma injury claims, and even those claims that involve an allegation of a specific and a cumulative trauma injury when those claims for injury are filed after the employee has terminated or separated from the employer. These are the post-employment claims, and you're going to be seeing a flood of these over your career. Some statistics indicate that there's as many as 30,000 post-employment claims being filed in the state of California every month. If you can believe that, every month. 30,000 per month, just of this particular species of claim, not to mention all the other types of claims that are being filed on a monthly basis, but just the post-employment claims, 30,000 a month, and your phone is ringing with these cases right now. And I showed you in that session how to identify these types of claims and how to handle them. And the discussion of post-employment claims spilled over into our 5th session, where we talked about how post-employment claims in general are barred, are banned, are prohibited. Claims that are filed when the employee has separated from the employer are generally prohibited by law. That's Labor Code 3600 generally bars these types of claims, but there are exceptions built into the law to handle those actual claims that actually represent true and bona fide injuries that the examinee, just for whatever reason, either didn't file them while with the employer or didn't know while with the employer that they were experiencing a cumulative trauma injury. In other words, the exceptions are built into the law to cover those cases that are actual bona fide cases that qualify for workers' compensation benefits. There are exceptions to the post-termination defense under Labor Code 3600. And in our 5th session, we talked about how to identify those exceptions, how to identify if your examinee qualifies for an industrial injury, even though the injury claim was filed post-termination, by discovering if your examinee fits into one of the exceptions that are described under Labor Code 3600. And this is where you need to become expert in discovering this information, because you're going to be flooded with post-employment claims. And these post-employment claims have a very specific handling. And the claimants that file these claims are very strategic and are very cunning, and they know the laws, and they're being coached by their attorneys on how to manipulate the exceptions. And so you, as a qualified medical evaluator, need to be able to identify those examinees that qualify for industrial injury and those examinees who do not qualify for industrial injury. And in our 5th session, we talked exactly about how to do just that. And then in our last session, we had another fascinating session where we talked about the face-to-face evaluation, where you sit knee to knee, elbow to elbow, and eyeball to eyeball with your examinee in an effort to ascertain the truth from them as to whether or not an industrial injury actually occurred or did not occur, and whether or not the symptoms that they're presenting to you at the time of the face-to-face evaluation can be traced to an industrial exposure, either specific or cumulative exposure with the prior employer. And we introduced the topic of some accurate interviewing techniques. And I shared with you some information from 2 studies about how to obtain truthful and accurate history from your interviewee. And we talked about how interviewees will manage their impression and will manage their information exchange with you in order to create a favorable and honest impression with you. And then we talked about a fascinating topic known as the verifiability approach. And that has to do with the details that the examinee shares with you during your face-to-face interview. And your job as the qualified medical evaluator is to try to determine which of the details that the examinee shares with you, which of those details are details that can be verified, and which of those details are details that cannot be verified. And as an example, many times examinees will tell you that they reported the industrial injury in some manner, way, shape, or form to a person in authority at their workplace, such as a supervisor, a manager, a human resources manager, and they will tell you that they reported the injury. But many times, if you accurately interview the examinee, you will ascertain that their claim of reporting the industrial injury is a detail that cannot be verified. They have no way to be able to verify to you that they indeed provided a claim form. They provided an incident report. They captured photographs. They captured video taping footage. They have no way to be able to verify the detail of the reporting of the incident of injury for which they're claiming an industrial injury. And that's not the only application of the verifiability approach, but I just give that to you as an example here. So up till now in this program, it's all about what the parties don't tell us that we as qualified medical evaluators have to determine for ourselves in order for our opinions and conclusions at the completion of our QME report to be accurate, to be some semblance of the truth, to be the most accurate representation of the examinee's situation, condition, impairment, whatever. It's all about being accurate, and being accurate requires that you be a QME forensic super sleuth. Okay? And now in today's discussion, let's talk about what they don't tell us in deposition, which if we knew going into deposition, if we knew the issues that were being deposed for, if we knew the questions that the parties are going to pose to us in deposition, we could perform so much better in deposition and feel so much better about ourselves and feel much more certain that we did a good job in deposition. But unfortunately, we're not privy to this information in advance. So I want to share with you what they don't tell us about depositions and how you can come out of your very next deposition smelling like a rose and feeling proud that you did a fabulous job. Okay? So with that as our introduction, let's begin today's session. Okay, so let's begin. So imagine this. Imagine your phone rings and you answer the phone, and on the other end of the phone is a legal secretary for the law firm associated with one of your recent claimants or examinees for industrial injury, for whom you provided a QME evaluation. And she wants to know what 5 dates you have in the next 8 weeks available for deposition. And so as you get out your calendar and you start looking over available dates for deposition, you're thinking to yourself, why in the world would they be calling me for deposition? Why are they calling me? Okay, so this is the applicant attorney, or this is the defense attorney. Why are they calling me for deposition? And so you do as you're asked, and you provide 5 dates for deposition, and the legal secretary informs you that she'll contact the other party, and she'll get back to you with a confirmation as to the day, date, and time. And after you hang up the phone, you pull open your computer and you open up the QME evaluation of this particular examinee. And as you go through the QME evaluation, you're wondering to yourself, why are they calling me for deposition? What do they want to know? What didn't I address? Where was I wrong? Right? You always ask yourself that, right? What did I do wrong? Where did I opine without support? Where did I stick my neck out? What did I say that wasn't true? What did I conclude for which there was no support in the medical records? How did I contradict myself? How do my opinions and conclusions contradict the opinions and conclusions of others? And 1,000 questions go through your mind wondering, why are they calling me to deposition? Well, as the next couple of days and weeks go by, you still wonder this to yourself. And as the deposition approaches, you start to have a new set of wonders and a new set of worries, wondering, I wonder what they're going to ask me. I wonder what the issues are, and I wonder what they're going to ask me. And how will I answer correctly? And how will I answer this? And how will I answer that? And what if they ask me this? And you might even call up a colleague of yours and attempt to troubleshoot some of the issues that the colleague finds in your report that you may have overlooked when you wrote the report yourself. And so there's this whole confounding process and this whole anxiety that confronts us as the qualified medical evaluator about upcoming depositions. And you wonder to yourself, well, where will the deposition be held? And what will the environment be like? And who's coming? Is it a male applicant attorney and a female defense attorney, or vice versa? And who's going to be there? Where will it be? And what will the environment be like? Will the room be comfortable? Will it be spacious, or will we be close together? And there's this whole anxiety that qualified medical evaluators have about attending deposition. Well, what I want to share with you today is designed to give you some relief and some comfort about approaching your very next deposition, because the number of issues for which you're called to deposition, number one, the number of issues for which the parties can call you to deposition, and number two, the numbers of questions that the parties can confront you with at deposition are finite, are limited. It's not an infinite number of issues. It's a very finite number of issues. And if you can understand those issues, you can feel more comfortable preparing for those issues, and you can feel more comfortable going to the deposition. Similarly, the number of questions about those issues that the parties can spring on you in the hot, confined, no air circulating room of the deposition room is very finite. And so if you can get a handle on those, you can perform beautifully. And you can feel good about yourself, knowing that you presented yourself professionally and as a well-qualified medical evaluator, and you can feel good about yourself. And you can actually look forward to depositions as the educational and profitable experience that they actually are. So let's begin today's session talking about the most common reasons that depositions are called for. And this has to do with the most common reasons that the applicant attorney would call for a deposition, and the most common reasons that the defense attorney would call for deposition. And then within those reasons, what are the most common questions that you're going to be faced with related to each of those issues? Okay, so let's talk about the most common reasons that the applicant or defense attorney would call you for deposition. Okay, so before we get into that, let's first talk about some of the labor codes and codes of regulation that deal with the deposition process. So the first one I want to share with you comes from CCR Chapter 4.5, Subchapter 2. It tells us that the Workers' Compensation Appeals Board, it favors cross-examination of medical witnesses like us, we're medical witnesses, by way of deposition. Deposition, in other words, you're not going to be called to come down to a courtroom atmosphere. Long before any of that takes place, the parties cross-examine you by way of, number one, supplemental report, or number two, by way of deposition. So you're going to be called to deposition throughout your career, and reasonable costs in connection with such deposition shall be allowed under Labor Code Section 4621. And let's just talk about those fees here for just a minute, because those fees are expected to handsomely increase over the next several months if the new proposed medical legal fee schedule actually takes effect as it's proposed. So let's talk about that. So fees for medical legal testimony are currently, at the time of this recording, governed under CCR 9795 and billable under the Medical Legal Fee Schedule Code of ML 105. So let's read the code as it exists right now. It tells us that fees for medical legal testimony, the physician shall be reimbursed at the rate of RV5 for each quarter hour or portion thereof, rounded to the nearest quarter hour, spent by the physician for all activities spent in preparation, travel, actually presenting for the deposition, travel back to your office, etc. So we're paid by the quarter hour to the nearest quarter hour under this code. It tells us that the physician shall be entitled to fees for all itemized reasonable and necessary time spent related to the testimony, including reasonable preparation and travel time. So track your travel time meticulously, both to and from the deposition location. The physician shall be paid a minimum of 1 hour for a scheduled deposition. Currently, at the time of this recording, we're currently being paid $255 per hour, but good news, the new proposed medical legal fee schedule is projected to increase our hourly rate billing to $455 per hour. And I sat in on this discussion and I participated in this particular fee structure. And this particular fee structure was arrived at because of the special demands that depositions place upon us as qualified medical evaluators. The deposition, many qualified medical evaluators feel that the deposition is a very stressful time. It's a time where they're called upon to perform, and they're called upon to perform credibly and professionally, and many qualified medical evaluators do not enjoy depositions. And so in order to consider and compensate qualified medical evaluators for the particular demand that's placed upon them during deposition, the Division of Workers' Compensation has agreed upon a handsome pay increase for us for our deposition testimony. So that's good news. Okay? So let's talk about why it is that you could or would or sometimes should be called to give your deposition testimony. So let's talk about those reasons, and let me set the stage for you for this discussion. One time I was giving deposition testimony myself, and at the deposition were, of course, two attorneys, an applicant attorney and a defense attorney. And the applicant attorney I had had some prior cases with, and I had a casual relationship with the applicant attorney, meaning I had seen the applicant attorney around town, at the post office, the grocery store, and acknowledged the applicant attorney at these locations, but didn't have any relationship beyond that, beyond the couple of cases that we had in mutual, that we had mutually. And so this was my first chance to, speak to the applicant attorney and get his take on depositions. And so we went through the deposition, and it seemed to me to be a nonsensical deposition. There wasn't really any issues of any great importance handled at the deposition. And after the deposition broke up and the defense attorney left and the court reporter left, and the applicant attorney and I were sitting there together in this room together, and I asked the applicant attorney, I asked him, what about this deposition? This was a silly deposition, seemed like a complete waste of time. And I asked for him to provide me a list of the top 10 reasons that a defense attorney would call for a deposition and the top 10 reasons that an applicant attorney would call for a deposition, and he provided me with such a list. Now the list I'm going to share with you in today's discussion comes from the perspective of the applicant attorney. Now the list might be different if I ask the same question of a defense attorney, but what I'm going to present to you today is the list of reasons from the perspective of the applicant attorney. And I'm just going to share with you just a small handful of reasons as to why the defense attorneys and as to why the applicant attorneys would call for your deposition. So this applicant attorney provided me the list of the defense reasons, and he told me number one, top reason. This was the number one reason, and that is to generate more billable work hours for the defense law firm. Now, remember, this comes from the perspective of the applicant attorney who cannot bill for attending deposition. So applicant attorneys and defense attorneys have a different perspective on depositions in that one gets to bill, whereas the other one does not get to bill. So you need to be aware of this. You need to ask yourself, is this simply the defense attorney, if they are the one that are calling you to deposition, are they simply trying to generate more billable hours? Because they certainly will be generating billable hours. Reason number 2 is to harass the applicant attorney, and this is coming from the applicant attorney himself, hoping to consume so much of the applicant attorney's time to make the applicant attorney more likely to agree to a less than optimal settlement. In other words, as the time starts to accumulate on the applicant attorney sees his hourly wage and his profitability from the case dwindling and diminishing as time accumulates. And this is the great use of time. The defense attorney twists the applicant attorney's elbow by consuming so much of the time of the applicant attorney that any profit that there was in the case simply dissipates down to zero. The third reason that the applicant attorney shared with me that the defense attorney would use to call for you as a qualified medical evaluator to call for your deposition is to prolong the litigation to try to starve out the applicant. And I see this one happening all the time. In fact, true story, I myself have a deposition for tomorrow, and as this is being recorded, we're in early July, and this deposition has been rescheduled 3 times beginning from March of this same year. So from March, April, May, June, 4 months the deposition has been delayed, during which time I'm certain the applicant is being starved out and is running on fumes waiting for some resolution to their case. So the defense attorney wields tremendous power in the use of their time in starving out both the applicant attorney and also in starving out the applicant. Okay? Reason number 4 is to prevent the case from going to trial. In other words, blocking the case from going to trial early. In other words, creating a reason that the case is not yet ready for trial by claiming that we have not even yet deposed the doctor. And then repeatedly rescheduling the QME deposition, as exactly as what occurred in the case I just shared with you. Again, exhausting weeks and weeks and months of time in an effort to twist the elbow and gain a strategic advantage over the applicant and the applicant attorney. And then reason number 5, and this is not a complete list, I'm just sharing with you a few reasons from the list, is to actually discuss medical legal issues. And when the applicant attorney gave me his list of the top 10 reasons, this was actually reason number 10 cited by the applicant attorney, was to actually discuss the issues related to the case. Now, I don't know if the applicant attorney was just being sarcastic about that, but you may put this to the test yourself in your very next deposition and see how much wheel spinning and time wasting goes on before actually even getting into the issues involved with the particular case. Okay? So there's a small list of reasons for the defense attorney to call for deposition. What about the applicant attorney? So according to the applicant attorney, some of the reasons for calling for the doctor's deposition are as follows. And here in this section, we're going to also handle some of the questions that the applicant attorney might pose to you as the doctor in relation to some of these issues. So according to the applicant attorney, they don't have the same motives for calling for deposition as does the defense attorney. They don't have any of the financial incentive drivers as do the defense attorney. So the applicant attorneys are going to be more concerned about the issues of the case. So for example, in the case of an adverse opinion by the Qualified Medical Evaluator, they're hoping that the QME cannot schedule the deposition within 120 days as required by law in order to discharge and get rid of an unfavorable QME report. So for you as a Qualified Medical Evaluator, if you want to retain the case and stay on the case, make sure to schedule your deposition or the deposition within 120 days of the request, and this should not be difficult for you to do at all. But there's a small percentage and a small population of Qualified Medical Evaluators who are so busy that they cannot schedule within 120 days, and this is one avenue wherein the applicant attorney can get rid of the QME report and start over in hopes of getting a more favorable report for their client. Then issues turn to disputed issues related to the case and the claim. So for example, disputes about the permanent impairment rating and the application of the Alvarez and Guzman line of cases. And in every single case wherein you provide a permanent impairment rating, you can expect the applicant attorney to challenge you on the permanent impairment rating and to attempt to persuade you to provide a higher permanent impairment rating, both under the strict application of the AMA guides and then also through the use of analogies and alternative impairment ratings under Alvarez and Guzman. And they will present to you all manner of arguments in an attempt to obtain for their client what they consider to be the most accurate description of the permanent impairment rating. So always expect the applicant attorney to squeeze you and squeeze you and squeeze you for a higher and higher and higher permanent impairment rating because it's their job. Okay, so that is money issue driver number one, is the permanent impairment rating. Well, second money issue driver of the need for an applicant attorney to call you for deposition has to do with apportionment. And again, there are many possibilities to discuss here, and we'll just discuss one of them. And it pays for you to remember that with apportionment, apportionment deals with nickels and dimes, whereas permanent impairment deals with big dollars. So by the time you've rendered your big dollar permanent impairment rating, the apportionment determination determines how those dollars are divvied up and who has to pay what percentage of those dollars. And a certain percentage of those dollars are to be paid by the claims payer, and the other percentage is to be absorbed or assumed by the injured worker themselves. And the applicant attorney and the defense attorney have opposite and competing motives here. It's the burden of the applicant attorney to prove the percentage of permanent impairment due to the industrial injury, which is compensable for their client, always seeking to maximize the percentage of permanent impairment due to the industrial injury, whereas the defense attorney has the burden of proving the percentage of permanent impairment due to other factors other than the industrial injury, which are non-compensable and which are to be assumed by the injured worker themselves. And the defense attorney is going to continually strive, and twist your elbow to increase the percentage of permanent impairment due to other factors. The applicant attorney is going to strive to increase the percentage of impairment due to the industrial injury. The defense attorney is going to strive to increase the percentage of permanent impairment due to other factors. And let's talk about how an applicant attorney might approach you with some questions in a case wherein you provided for some apportionment of the permanent impairment to other factors in the form of degenerative changes found on x-rays. Okay, so this is a very common scenario. Many qualified medical evaluators, in providing their apportionment approximate percentages, will provide a certain percentage of the permanent impairment to be due to other factors, non-compensable other factors, such as degenerative changes of the spine, of the shoulder, of the knee, of the hip, etc. And let's just see some questions, and let's see if we can anticipate some of the questions that the applicant attorney might ask you in an attempt to discredit your apportionment determination and in an effort to increase the compensable permanent impairment due to the industrial injury. Okay, so let's explore some of those lines of questionings here. Okay, so imagine this. Imagine you have an examinee and you've provided a permanent impairment rating to describe the examinee's condition. And let's just say your apportionment percentages were 75% of the permanent impairment due to the industrial injury and 25% due to other factors. Well, the applicant attorney is going to be motivated to get the apportionment percentage more closer to 100% due to the industrial injury and 0% due to other factors. And the applicant attorney is going to be more and more of a dog on a bone the more ground he or she has to gain towards the 100%. So, for example, if you provide an apportionment determination of 50-50, the applicant attorney is going to be extremely motivated, more motivated than they will be if you provide for percentages, for example, 90-10. And in this example, let's say you provide apportionment approximate percentages of 75% due to the industrial injury and 25% due to other factors. What line of questioning can you anticipate? Well, how about some lines of questioning that have to do with your understanding of the laws that govern apportionment that are currently in effect in the state of California? How about this question? Doctor, what is your understanding of Labor Code 4663? And then after you provide your answer, how does Labor Code 4663 apply in this case? And the philosophy behind this question has to do with your understanding of correct legal principles. In the Escobedo case, Escobedo told us that in order for your apportionment determination to qualify as substantial medical evidence, it must be based on correct legal principles. The opposite of correct legal principles is incorrect theories and incorrect understanding and incorrect interpretations of these laws. And so the applicant attorney is going to first test you to find out if you actually have a proper understanding and a correct understanding of the correct legal principles governing the apportionment approximate percentages. Well, if he's satisfied that you have some understanding of correct legal principles, the next reasonable question that you could anticipate would be something similar to the following. Doctor, with regards to degenerative changes, or whatever it is that you're apportioning to, such as obesity, such as diabetes, such as asymptomatic pre-existing conditions, such as retroactive prophylactic work restrictions, whatever it is that you're apportioning to, he's going to chip away at, right? He's going to ask you, what facts do you rely on to conclude that this condition, whether it be diabetes, obesity, whatever, is causing impairment at the time that you evaluated the examinee? So by impairment, we mean functional loss of use, or limitations with activities of daily living. So remember that with the apportionment determination, you're providing the parties with your opinion as to the multiple factors that are contributing to the examinee's impairment on the day that you evaluated the examinee. So if you apportion to degenerative changes or pre-existing conditions or whatever, you have to have some facts to support your opinion that that condition is contributing to the impairment. You have to have some facts, and he's going to ask you to show your cards. He's going to ask you to expose your facts, to show your hand. And your facts better be good, and your facts better be relevant to the case. See, there's a difference between facts and relevant facts, okay? And your facts have to be relevant to the determination in question here at the deposition. Okay? What other questions can you anticipate if you decide to apportion to any other factors? Well, one question that you can anticipate has to do with how these other factors, such as obesity, diabetes, degenerative changes, what have you, which were in effect prior to the industrial injury, how were they affecting the examinee prior to the industrial injury? And were they causing impairment to the examinee prior to the industrial injury? Or is it just that the industrial injury now occurred, and now because you found degenerative changes, or because the examinee is obese, now you opine for some apportionment to those conditions? You can expect this to be pursued by the applicant attorney. So a question that you can anticipate has to be, number one, what evidence do you have to indicate that the diabetes, the obesity, etc., was causing impairment prior to the industrial injury? Prior to the industrial injury. This is going to have to do with those examinees that present with pre-existing conditions that were asymptomatic. If you're going to provide for some percentage of apportionment to those conditions or those factors after the industrial injury, you can be prepared, and you better expect that the applicant attorney is going to want to know, in your opinion, how did those conditions cause impairment prior to the industrial injury, because those conditions were present prior to the industrial injury. And he may follow that up with asking you, how does it affect your apportionment opinion when we know, in fact, that the other factor was not causing any impairment? There was no functional loss, there was no interference of activities of daily living prior to the industrial injury. So this is an example, doctors, as to how the apportionment determination is going to be approached by the applicant attorney, and you can anticipate a similar line of questioning from the defense attorney in those cases where you provide for an apportionment approximate percentage due to the industrial injury. The defense attorney is going to take the other tack and attempt to downgrade and downplay the percentage of permanent impairment due to the industrial injury. Okay? So this has to do with a couple of questions regarding apportionment and some of the medical legal issues surrounding the case. What other types of questions can you anticipate in your very next deposition? Let's talk about some of those now. So what are some of those other questions that you can anticipate in your very next deposition? I wondered this myself, and I speculated, and I pondered on this for a long time, and then I had an idea. I had an idea to take my last 10 deposition transcripts, and I want to encourage you to save every single one of your deposition transcripts and read those deposition transcripts periodically to learn from those deposition transcripts. And always ask yourself, what is the philosophy behind the question that's being asked of you by either the applicant attorney or the defense attorney? So I took my last 10 deposition transcripts and I extracted from the deposition transcripts every question that was posed to me. And I organized the questions by whether or not the question was posed to me by the applicant attorney or whether it was posed to me by the defense attorney. And I took a look at all of those questions and I organized the questions by categories. And I have that for you right here. These are all the questions asked of me in my last 10 depositions. And this is a 23-page document, double-sided. And the major categories of questions that I was able to elucidate from these deposition transcripts had to do with introductory questions, and I'll share a couple of those with you. Familiarity and preparation questions. Questions that attempt to ascertain your experience as a qualified medical evaluator. and also your experience in deposition. And then questions regarding the medical legal issues involved with the case, such as causation, such as mechanism of injury, such as the permanent impairment rating, such as questions that get you as the qualified medical evaluator to either admit or to deny the need for an additional QME in another specialty, and then some questions related to QME process and procedure. So I'll just share with you a couple of questions from some of these categories, not all of them and not from all of the categories, but just to share with you some questions that come from each of these major topic headings. And I'm sure you'll recognize these questions as operative in your own depositions as well, if you would review your recent deposition transcripts. Okay, so for example, some introductory questions would include, good afternoon, doctor. Can you state your full name for the record? Okay, doctor, have you had your deposition taken before? This is an introductory sort of rapport building and get the process going type of question that is not related in any way to the medical legal issues involved in the case. Doctor, have you had your deposition taken before? Have you ever been deposed before besides this case? Doctor, you took a thorough history from the examinee during your evaluation, correct? Isn't that correct? Or is that correct? Okay? And so these are some various types of introductory questions that are designed to get familiar with you and to get the ball rolling. Now the next category of questions has to do with familiarity and preparation questions. And some of those questions could include, doctor, you served as the panel QME case for Mr. Jones. Is that correct? And that's correct. You evaluated him on one occasion. Is that correct? And the parties are getting familiar with the details of the case and bringing the details of the case out into the open and out onto the table so that the discussion can begin. As we sit here today, tell me if you recognize this question. Do you have any independent recollection of Mr. Jones? Did you review any documents or chart notes in preparation for your deposition here today? And this is a familiarity and a preparation question. They need to know how you prepared and what you reviewed for the deposition so that you can all be on the same page. And therefore, if there's something that is a document that you did not review, the parties will know that this will be an opportunity that they can raise awareness of that document, knowing that you did not cite this document as one of the documents that you reviewed in preparation for the deposition. Let's go on to a couple other types of questions. How about ascertain experience? This is where they ascertain your experience as a qualified medical evaluator. Doctor, when did you start doing QME work? How many QME evaluations have you done this year? How many have you done lifetime? How many QME locations do you have? How many QMEs do you do in a year? How many do you do in a month? How many times have you been deposed before? They're ascertaining your experience as a qualified medical evaluator to likely get a sense as to how familiar you are with correct legal principles and how familiar you are with the various aspects of the QME evaluation, including your familiarity with the AMA guides. Okay? And many, many other questions relating to causation, relating to the mechanism of injury. Of course, you're going to get questions related to your permanent impairment rating. Let's talk about a couple mechanism of injury questions, and then we will conclude today's program. An examinee who fell. This is an examinee who fell and who was caught while falling by a co-worker. Do you know if there's a size discrepancy, a size or a weight discrepancy between my client and his co-worker who caught him while falling? So this is a question regarding the mechanism of injury. Do you know how long my client laid on the floor after striking the floor? Do you know how long he laid on the floor? Do you know whether he struck the left side of his body, whether he struck the right side of his body? Did he strike his hip? Did he strike his shoulder? When he was lying on the ground, was he lying on any body part? And all these questions related to the mechanism of injury. So doctors, I hope this helps you. You know, depositions can be a great learning experience for you and help you learn the case from the perspective of the other parties. I always enjoy depositions because we as qualified medical evaluators, we're familiar with the case from our perspective. Well, the other parties to the case have their perspective as well. And it's only in deposition that we learn what the other perspectives of the parties are. And if we can learn some of the perspectives of the other parties, it helps us better prepare our own arguments in the future so that we can anticipate the needs and the perspectives of the other parties, and we can address those in advance. So doctors, I hope this helps you. And I want to conclude today's program by just summarizing the whole philosophy of the QME Forensic Super Sleuth. And that has to do with you becoming the very best qualified medical evaluator of which you're capable. And in order to do that, you need to continue to expand your experience and continue to expand your learning and your knowledge of the issues that govern the cases that we as qualified medical evaluators are called upon to evaluate. We think that when we evaluate an injured worker, we think that our agenda and our procedures and our intentions are the only procedures and the only agendas that surround the particular case or claim, and that's simply not true. And the more that you can understand the needs and perspectives of the other parties, which they don't tell us, they don't tell us this, but the better you can understand the needs and perspectives of the parties, the better qualified medical evaluator you can become, because you'll have a better ability to address those needs, to resolve those issues, to handle those disputes by knowing what are the issues around the disputes that need to be resolved, and knowing how those particular issues are resolved in the system can allow you to actually help move cases forward in the system and prevent the logjam and help alleviate the logjam that has currently got cases backlogged in the system into the months and even years. So this is all about how you as a qualified medical evaluator can become the best medical evaluator possible by knowing that which they don't tell us. Okay? So I want to thank you for taking the time to join me on this discussion, and I also want to take a moment here to sincerely appreciate you for your commitment and your dedication to excellence as a qualified medical evaluator. For now, this is Dr. Perry Carpenter. I'm looking forward to being with you on future presentations, and for now I'm wishing you best of success.